So we're almost done with the walkthrough. Oh, and I'm trying to move your screen and not mine. Where are we, Michelle?
Okay, I'm just going to go back to this issue on page 21 about who has access under what circumstances for how long. So I did just want to clarify that in subdivisions 3 and 4, where there is a look back for certain folks with regard to the sealed records, is it doesn't apply to the offenses that are no longer criminal. I just wanted to note that because I think that Joe said something about that, and I wanted to just note that there is not a look back for those types of offenses. So those are completely sealed.
All right.
Okay. Okay.
Thanks.
Sure. So I'm going to move on. So we just talked about DOC having access for a certain period of time, and for the court and the parties having access in subsequent cases for sentencing purposes. We talked about the disclosure by attorneys. If you look at subdivision 6, upon request, the victim's compensation program is to be provided with a copy that's redacted of all the identifying information for the sole purpose of verifying the expenses in a victim's compensation application. So you'll probably hear from Jen Pullman as a witness, and she can explain to you why they wanted access to that information for verifying expenses. You'll see subdivision 7, the sealing shall not affect the authority of the restitution to enforce a restitution order. Again, remember that in all of the different provisions for sealing, before the judge makes a determination whether to grant the petition, that the person does have to satisfy any restitution that has been ordered.
Okay.
And then subsection D, these are exceptions with regard to dismissed charges. Up above in C, we were talking about convictions with regard to charges that are dismissed without prejudice. So those meaning that those cases can be brought back again. So they've been dismissed, but the state's attorney or the attorney general's office can come back and pursue that case. The prosecution has access to dismiss cases for 3 years. The prosecution may object to the loss of access after 3 years by proving that the loss of access would pose a significant risk to public safety.
Michelle?
Yes?
If I could just ask that we unpack that a little bit. So the prosecution may object, but then it says they may object by proving. So am I assuming that they may object, that stops the process while there's some sort of court determination or hearing at which they have to prove, and then the court has to agree?
Yes, you know, honestly, I don't remember the discussion about this that much, and I can't recall when, at what point this came in. So I don't know, I'm guessing that this probably came from prosecutors, and so when Evan testifies, he might give a little more background, and then I'll go back and look at my notes, because I don't remember talking about this a lot. So
Okay, because I, you know, one of the things we've heard that there are state's attorneys that sort of routinely object to every petition as a matter of course. And I'm wondering, would this allow somebody to object to all of these if they believe that they shouldn't be sealed? Could they just routinely object to everything and stymie the process?
I think probably talking to the witness would be the best, with witnesses and perhaps the defendant's
Okay.
office.
Will do.
So,
Yeah. So I'm just going to speed it up a little bit because I know that you want to hear from Evan. So top of page 24, this is the penalty provision. And Senator Baruch was the one who proposed this, and Justice Oversight, that there be a penalty for unauthorized disclosure by someone acting on behalf of the state. who in the course of their official duties knowingly discloses sealed criminal history record information in violation of the chapter, and it's a civil penalty of not more than $1,000.
I do have a couple of questions here, Michelle. First of all, it's a penalty for disclosing, but I'm wondering why it's not a penalty for accessing the records. So in other words, you've got somebody who doesn't have the right to access them, but they're curious, or they want to, they just want to see for other investigative or prosecutorial purposes. And so they go in and they access the records, but they don't tell anybody. I think that should still be an offense myself. And then the other thing is, it says in the course of their official duties, disclosing. So if somebody is not in the course of their official duties and they access or disclose, does this allow them off the hook?
So, so this was an issue that kind of went back and forth. I think I'm trying to remember what the original language, the genesis of that. And then the Center for Crime Victim Services, I think, expressed some concern around making sure that it would not apply to folks who were not doing it, who like had information, perhaps like a victim who had information and was disclosing information about circumstances that had happened in an earlier case. And this was the kind of compromise language that folks came down to. And I'd have to check my notes to look at that, but I understand your concern there. And with regard to the authorization, the access issue, I think I was modeling the language that is currently in Title 20 with regard to disclosure, unauthorized disclosure of record information that's contained in Title 20 for BCIC, but I can double check. And you can certainly add there, access or disclosure.
Yeah, I would favor that, but what Senator Sears mentioned a while back, that Commissioner Sherling testified that he wanted officers in the field as they're conducting, let's say, roadside stops to be able to access this. That's my nightmare of how this works, is people just sort of treat it as though it's information that they can dip into. So you have somebody who conducts a roadside stop, they somehow call in, get access to this information, find out about this sealed crime. They treat the person differently, but they don't disclose anything. So they wouldn't trigger this at all, as far as I can see. And so I would rather have it rewritten to make it clear that people are at risk of this penalty if they access the information as well as disclose it, and make it clear that it can't be used in any, by a law enforcement officer against someone in the field.
Sure.
Thank you.
I think also is that something that I'm hearing a little thread through some of y'all's questions is I think it might be helpful when you're speaking to some of the witnesses to ask them their agency's policies of how they currently operate in complying with existing sealing orders. Because, while you're just expanding the universe here of the types of records that can be sealed and the timelines for seal and stuff like that, all of these agencies right now have to comply with sealing orders, and they all have their own separate policies and procedures for how they do that and how their records are kept. And so I would just encourage you, whether you're talking to Commissioner Sherling and about how they deal with it at the state police versus how DOC does it, and things like that, to be talking to them about how they currently operate with compliance. Because those are things that are not necessarily spelled out individually in statute.
All right.
So the next one is Section 7, and this relates to expungement of municipal violation records. You may recall that last year in Evan, you provided a process for expunging certain traffic events that has to toll from satisfaction of the judgment. Here it is 3 years. Then Judicial Bureau shall make entry of expunged and notify the municipality of the action. So there are some exceptions, and that is you'll see on lines 15 through 17, essentially zoning infractions, things like that, are exempted from this. But all other municipal violations are eligible. And then you'll see subsection B, effective expungement. And again, this is when I think Joe was asking, well, is expungement just gone? No, there still are some places in law where there is expungement, was expungement, and that's not changing. It's more of the general kind of sealing expungement that's merged in the Title 13 provisions that are changing to sealing.
Can I ask a question about this? What kinds of municipal violations would be covered under this? I mean, I can look up 24 chapter 117, and see what isn't covered. But if you have a barking dog and violate the noise ordinance, is that, I mean,
Yeah, you have a big one. I remember when people were adopting from Korea, there was an incredible record check, and if you had violated the leash law, you became ineligible. So people had to get that whole thing, go through court, get that record sealed,
okay.
because it goes far ranging.
And so why would we make them wait for 3 years to expunge the violation of a leash law or a barking dog or any of those town ordinances?
I think it's just a policy decision for
Okay.
you. It was the city attorney for Burlington, Dan Richardson, who proposed that there be a parallel to the traffic offense one for municipal violations. The league came in and testified, and they asked for it to be expanded from 2 to 3 years. So they wanted a longer period of time.
I can see on the zoning violation.
Well, that's not
covered.
not covered at all.
That's not covered at all. What are the other things like that might not, that aren't covered? Municipal, can you think of anything mentioned?
You mean in that chapter? No, I mean, I think that I would have to go look, and I don't practice that area,
Yeah.
but I'm sure that your witnesses can talk to you whether it's.
And why don't we move along to,
And so just a note here is that at top of page 26, the application as the section for sealing or expungement of the municipal records is to apply to violations that occur on and after July 1st of this year when the act takes effect. So it's not gonna, so it's gonna be prospective.
Oh, that's good.
And then similarly, what was the Judge Knight asked for there to be something, a similar provision added to what you passed last year for the traffic violations is he wanted that to take effect from the date that S7 took effect. So that traffic violation one is applying only from July 1st of 2021 forward.
okay,
And then that's it, because I don't necessarily need to go, I mean, I can at some point, but I know we're pressed for time. There is this automatic sealing study committee, which is just 2 House members, 2 Senate members working with legislative counsel to come up with a proposal, a draft legislation for automatic sealing, but that is being taken out by House Appropriations.
okay. I have one request, Michelle, for a future meeting. If you could get us all the information on how juvenile cases are sealed and who has access and when they have access. As forever, juvenile cases have been sealed after the juvenile turns 18 with some exceptions. So I'd like to understand how this is dealt with. I mean, police, everyone has dealt with the sealing of juvenile records for years. I don't even know when that started, but it's long before my time in the legislature. So let's say at least 50, pardon me?
Be super quiet. I have to testify soon. And you might not want to come downstairs,
Okay,
okay?
okay.
I'm guessing for that.
Let me start that request over. For at least 40 years that I know of, records have been sealed. I want to understand how that works currently. Who has access to those records, when they are accessed, all of that information. I'd like to compare that to what we're proposing here in terms of sealing.
So I can remember shredding a lot of records
Yeah,
that were.
Yep.
After a certain period of time.
yeah. So
Shredding.
if I could better understand what happens to the 15-year-old that was found to be a delinquent for X offense, doesn't matter what the offense is, what is the effect of that sealing? Who has access 5 years from then? Okay, and I know it might be in the juvenile law and somebody else, but it just would be helpful to understand. And as we try to make decisions about our policy about who would have access. All right. I'm going to take Evan Meehan if nobody objects next, because he has to get to the Supreme Court. And we don't want to keep him from the Supreme Court.
Who's already.
Good morning, and thank you for accommodating my schedule. I really appreciate it, and my apologies to Attorney Jacobson for taking the time in front of her. For the record, my name is Evan Meehan, and I'm a Deputy State's Attorney working in the Executive Director's Office of the Department of State's Attorneys. Shortly before the committee hearing this morning, I submitted a memo on behalf of the department that outlines our remaining comments to H534 draft 5.2. Given the nature of the conversation that's happened so far today and the time remaining, I'd like to just take a step back from that memo for a moment. Perhaps on another occasion, I could go into it in some more detail, but I would like to just briefly explain what the department's position is in general on the question about sealing versus expungement, and then also really hone in on this issue of the state's discovery obligations, which there were some questions about. As stated in the memo, the department is generally supportive of the recommendation from the Joint Legislative Justice Oversight Committee and the memo that Attorney Childs reviewed earlier today. And that recommendation was to move from a 2-track system of expunging and sealing to a 1-track system of sealing. The primary reason why the department supports that recommendation is because it really balances the desire to provide relief from the burdens of criminal convictions while allowing the state to meet its discovery obligations that are mandated not only by the rules of professional responsibility, but both the Vermont and federal constitutions. H534 draft 5.2 really makes some meaningful and positive progress towards making that shift to a 1-track system. And I want to note that shift, as a practical matter, will not impact anyone whose record has already been expunged. Because the record was expunged, it's been destroyed under Vermont law. There's really no way to recreate it and somehow reopen it back up, because only the judiciary is allowed to maintain, an index of what offenses have been expunged. So these changes are really only going to apply prospectively and will not impact people who have already had the benefit of an expungement under Vermont's laws. Another reason why the department supports this shift is because 41 out of 54 states already basically have sealing only, even when they use the word expungement. In other words, when you look at what other states are doing, they might use the term expungement, but they don't require the total destruction of the underlying criminal information. And earlier in the summer, the department gave a presentation to the Joint Legislative Justice Oversight Committee that talked not only about some trends that it's seen in other states, but also some of the concerns about a defendant's access to information and discovery. And there's a link to the PowerPoint presentation in the memo that I submitted this morning. In terms of a defendant's access to information that has been sealed, I want to touch on that very briefly before moving into discovery. Under H534, the defendant would have access to the sealing order, but would not have access to the underlying information and file that has been sealed. And in the PowerPoint presentation that I just referenced, I give an example from the real world where I was the recipient of a public records request by someone asking for a copy of their record in order to use the information to challenge a professional license revocation. And I had to tell that person that no records existed because I had been ordered to expunge them. So that person got no records in order to use them himself. And I don't necessarily think H534 would change that circumstance. In terms of discovery, the presentation, PowerPoint presentation, also gives a couple hypotheticals, and I'm going to summarize them orally. But I think it's important when we talk about discovery to keep in mind that this is not necessarily talking about the defendant whose record has been sealed. So I'd like to shift the focus away from the defendant and towards other participants in the case. For example, a witness or a victim. And when I say witness, that also could include law enforcement officers. So I'd like you to just think about this situation for a minute. A victim or a witness, who may be a cop, says or does something in the course of an investigation or a prosecution. What they do or what they say might have some bearing on their credibility. For example, a cop tampers with evidence. A witness says something that's false or misleading. And then the case in which that happens is sealed. It may even be that the case was sealed because the state dismissed it as a result of that credibility information. The state thinks that it's important to be able to use that information in discovery. For example, let's say that same witness, victim, or cop has some involvement later on in the criminal justice system. Maybe they're a witness in another case or a victim in another case. The state needs to be able to disclose information pertaining to their credibility to the defendant in the future case so that that defendant can defend themselves against the charges. Right now, under law 7607, the state can use sealed information in discovery to satisfy its ethical obligations and its constitutional obligations. H534 would allow the state to continue to do that in cases that result in a conviction, but would prevent the state from doing that in cases that don't result in a conviction. For example, when the state dismisses a charge because of the information pertaining to the witnesses or the victim's credibility. I'd like to point out that these are not just hypotheticals that I'm providing. Since I've joined the department and conversations have started about this issue, a few prosecutors have flagged where this has actually come up. And there's two examples that I give in the memo that I submitted, both of which are domestic assault prosecutions. In one case, a defendant filed a motion to dismiss the domestic assault charges because the state had complied with an order to expunge records associated with a case against the complaining witness. In other words, the defendant said, the records from the victim's case are discoverable in my case. You've destroyed them. I don't have access to them in discovery, which means court, you need to dismiss the charges against me. The state made the decision to dismiss the case without prejudice before the court ruled on the motion. In another case, the state dismissed charges were against the defendant because it was unable to disclose information about the complaining witness's credibility from a prior expunged case. And this second example really illustrates the problem, because the rules of professional responsibility require prosecutors to disclose information that they know about, not just information in records that they possess. So in this particular case, the records had been expunged, they had been destroyed. There was nothing tangible that the state could produce, but the state knew that the exculpatory information existed, and it was stuck between a rock and a hard place. Does it disclose the information that it knows about and violate the expungement order, or does it refrain from disclosing that information and potentially result in a discovery violation? And I'm not here to say that these types of issues are going to pop up often or even frequently. But I think when we talk about discovery, it's important to keep in mind what the underlying purpose of these ethical and constitutional obligations are. The purpose is to ensure that criminal defendants have all of the information that might undermine their guilt so that they can defend themselves. This is about ensuring that individuals have access to the information they need to rebut criminal charges. And so this isn't real. Yes.
Mr. Chair.
Yeah.
Just a quick question, Evan. So I take your point as I would summarize it. You're arguing that there might, in an expunged case or even a sealed case, there might be some auxiliary piece of information that bears on a future prosecution. And so it would be better for the state to continue to have access to that information. But it seems to me that the whole project of expungement was to remove somebody from the state's grip, the Justice Department's grip, and to have this case go away, to have the offense go away, and to allow them to go on with their lives, and to have it not be continually accessed as we go on in time. So understanding that that's the basic idea behind expungement, if we go to a one-track system, it seems to me we have to import some of that. And that means, in my mind, that we are thinking about it from the defendant's point of view. We are thinking about it from the point of view of the person who was charged and convicted and is now expunging, or who had the charges dismissed, or who was convicted, but it's no longer a crime. So, in the balance of things, the state will lose some of its options because the legislature has decided to move in favor of defendants in these particular listed cases. So at what point do you think it's appropriate for the people you're talking about to relinquish that right to that sort of auxiliary discovery?
Yeah, that's a great question, because what it really does is it frames up really well the fundamental issue, right? What we're really talking about here is balancing the desires of a large group of past defendants against the constitutional rights of a few future defendants. That's the question, right? A large number of past defendants could benefit from this statutory right to have their record expunged or sealed. But the question is, what happens when exercising that right comes at the expense of a future defendant's constitutional right to exculpatory information. And that's the fundamental policy question that the House Judiciary Committee and this committee are going to be evaluating. And I can't help but think about other conversations that have been happening around other bills. For example, in government operations the other day, when we were having a conversation about a Brady-Giglio database. What happens when the state recognizes that a law enforcement officer has done something that calls their credibility into question, and we issue a Brady-Giglio letter? And then the case that letter stems from, and that letter references information from the case, is sealed. What happens to that letter? Can we no longer disclose it in a future criminal case? Or what happens when a defendant reads about it on a newspaper article? Can the defendant then go into trial and use the information from the newspaper article to try and impeach a witness, even though everybody is supposed to be pretending that this never happened? And so to answer these questions, I keep going back to what is the effect of expungement and what is the effect of sealing? By statute right now, it says that the person shall be treated in all respects as though the conviction never happened. And in response to any inquiry from the public, the government has to say no records exist. And that really narrows the nature of the inquiry into, okay, we're drastically limiting public disclosure. And now what we're talking about is legitimate government uses. And what are those legitimate government uses? The state's attorney's request is incredibly narrow and tied only to discovery to satisfy constitutional and ethical obligations. And there's a few other recommendations in the memo that talk about ease of application. In other words, things that we could do procedurally to make this law easier to implement, to help identify what cases have been sealed so that we know what not to talk about. And then there are a couple other substantive recommendations that we make. I don't know that there's time to get into those in great detail, and I do apologize for that. But I'd be happy to come back at another time if that would be helpful for the committee. And in the few remaining minutes before I have to leave, I obviously will answer any questions I'm capable of answering.
Yeah. What happens now if it's a juvenile record?
That's a really interesting question as well. Because we have to think about both delinquency cases and youthful offender cases. And, you know, those, as you well know, those laws are even more complicated than these ones. But my recollection is delinquency cases are sealed. And for the most part, youthful offender cases are sealed, but in some circumstances,
I think they're expunged, aren't they?
I think it's information in the criminal division is expunged, and information in the family division is sealed. But I might have that backwards.
I think you're right. No, I think you're correct. Yeah. So that's what happens in the juvenile system. Kid was abused. Kid was, you know, we've all had these cases. Kids abused as a child by a parent, physically abused or sexually abused, then acts out based on that. And, you know, he's a juvenile, the record's sealed. Who has access to that if the father who abused the kid comes before the court?
My understanding is that there's no separate provision. There's provisions in the juvenile code that talk about when things should be sealed or expunged. But in order to understand what the effect of that is, I think we would still turn to 7607. Marshall Paul is present, and I'm sure he can clarify if that's his understanding as well.
I need to understand what we're doing here and how it, and what we do with juvenile and youthful offender. And also deferred sentences. Doesn't the same problem apply for a deferred sentence, which is now expunged, which has for years been expunged after the completion of the diversion? And there was a cop with bad information. Wouldn't that be a problem under current law?
It would be, yes. And H534 doesn't change the fact that a deferred sentence could still be expunged. I don't read it that way. And it is still a problem, but the issues that
No,
I'm
but I'm
raising would
saying
apply
your
there
issue
as
that
well.
you're raising here, I think we should be consistent in terms of access.
I agree. I agree.
So I need to better understand how that system works currently. It's been in place for years and I haven't heard of huge problems with it. The other,
Well,
when
I'm
you
sorry.
do come back, maybe you can be prepared to talk a little bit about that. My other question is what happens when the statute of limitations runs out on a crime that you didn't prosecute, but you're still able to prosecute? You know, it's dismissed without prejudice.
That's right. And there's one suggestion in particular in the memo that pertains to that very issue and the statute of limitations. But obviously, you know, this when a prosecutor can no longer move forward with a case because the statute of limitations has expired, the value of the information in that file goes down because we can't move forward with charges.
Can I ask a question?
Yeah.
Okay, thanks, Evan. I'm going back to the conversation we had the other day about the Giglio letters. And a letter would be put in the person's file. I mean, there'd be a letter or a disciplinary action, whatever you want to call it, in the at the Criminal Justice Council. And that would be there even if 10 years later the record was expunged. That letter is still there. And it seems to me that if there must be a way of recording it so that it can still be used to discipline the officer or the credibility of that particular officer. I don't know about other witnesses, how you would do that, but there has to be a way of doing that so that, and it's a long time anyway. I mean, in misdemeanor cases, it's going to be 6 years. And in the felony cases, it's like 16 or 17 years before they can get it expunged. So during that whole period of time, those letters are there and the record is still there. I mean, if you're talking about records 20 years from now, if
Yep. I think we're going to have to continue this conversation next week with Evan about the problem that he's identified, because he has to leave at 11:30 and I think we're at 11:30.
Yeah.
Actually, 11:31 according to my iPad. So we'll pick up with Aaron Jacobson from the Attorney General's office next. Thank you, Aaron.
Thank you. Good morning, Chair Sears. Good morning to the committee. I know Evan jumped off, but best of luck to Evan at the Supreme Court. For the record, my name is Erin Jacobson. I'm with the Community Justice Division of the Attorney General's office. At the outset, the Attorney General would like to just acknowledge and express appreciation for all of the steadfast work that has already gone into this bill, both by Joint Justice Oversight, by House Judiciary, but as well by all of the stakeholders. It's been a lot of work, and then also to thank this committee for continuing that work. Generally speaking, the Attorney General supports H534 in this current version and is especially in favor of expanding the list of crimes eligible for record clearance. We also support the establishment of a study committee to look into the possibility of automatic sealing. However, and as our office has consistently testified, including the Attorney General himself, We prefer expungement over sealing. Record clearance through expungement is our current law. And accordingly, we believe that any access to sealed records should really be as limited as possible. This would also be in line with what you heard this morning from the Joint Justice Oversight and their recommendation that if we're going to move to a one-track sealing process, that those sealed records should really be confidential to everyone except for the subject of record. And then any access allowed to others should really be only as necessary and for very limited purposes, which are clearly identified in statute. As well as House Judiciary heard from several witnesses, the very framework, the current framework that informed H534 comes from data and science regarding the predictive value of stale convictions on future criminality. So in other words, the likelihood that someone will reoffend over time. And that science, those studies informed the 3, 7, and 10-year wait times before a person is eligible to apply to seal their records once they have completed their sentence and paid all fines, fees, and restitution. So if access to sealed records is not limited and it's not narrowly tailored, if law enforcement has access to sealed records for use in the field, for example, then a bill with really good intentions, those intentions to create a pathway to record clearance for more Vermonters through expanding the eligibility, expanding the list of qualifying crimes, then all that happens is that then this bill really serves to diminish the rights that so many already enjoy through the expungement laws that we have. So, you know, our office feels that this sealing scheme should really track as closely to expungement as possible. And again, that any access should be very limited and narrowly tailored. I would like to mention that some of the access that is provided for in this in H534 version 5.2, I think we're on 5.2. Yeah. Some of the access we're completely fine with. For example, access that researchers can gain through a court order, access by victims' compensation program and the restitution unit, that's fine. But when we're talking about access to sealed records by law enforcement, prosecutors, and DOC, that's where we depart from some other stakeholders like state's attorneys and maybe Commissioner for Public Safety. So if I could, I just want to go through a couple of the provisions in 534 on page 21, beginning on line 12, where it talks about access to sealed records by parties and courts to inform sentencing in subsequent offenses. The Attorney General does not support that provision that provides that access. The Attorney General opposes this because we feel that old stale convictions for which someone has already completed their sentence, paid their dues, and then petitioned to have that record sealed, which a court then found was in the interest of justice, should not then inform sentencing for an offense many years later. That's really counter to what is provided currently under expungement law, the finality that expungement provides, and the assurance offered to those who've had their records expunged. As well, it undermines public policy related to notions about rehabilitation. So if an individual is going to complete their sentence, pay their fines, pay restitution, then years and years later, sometimes, you know, we could be talking 2 decades later, if they reoffend, then the sentence for that offense should really be about the individual in that moment at that time and meeting them where they are, not taking into account something that happened years and years in the past. Next, on page 21, line 19, access to sealed records by DOC. Similarly, we do not support that kind of access for similar reasons. The reason that DOC would want to maintain access of sealed records is for risk assessment and supervision determinations. But these assessments potentially lead to restrictions on a person's liberty. And so therefore, again, should not be informed by antiquated information that by that point it is not necessarily relevant to assessing risk, again, as informed by what we know about the science of reoffense and the predictive nature of those old offenses.
Could you get us those studies that you referred to?
Sure, there were several
If we don't,
studies.
are they available online? If you could point us to them, and Michelle may be able to get them for a future meeting.
Sure, it's definitely something that a lot of witnesses talked about in House Judiciary, and various advocates did submit, I believe also to Joint Justice Oversight, but I would happy to work with Michelle to make sure that you also have them.
Would be appreciated.
Sure, no problem. Regarding what Mr. Meenan was talking about with on page 22, line 5, access to sealed records by state's attorneys and the Attorney General for discovery purposes, that's not something that our office requested. And I would just note that as Evan explained, the constitutional or discovery concerns really pertain to protections for defendants' rights. And so we would just defer to the Defender General's office about whether they think that that is a provision that should remain in this bill. But I did want to make clear that that wasn't something that that our office wanted to make sure was in H534.
Okay.
I'd be happy to answer any questions should the committee have them. I guess I could just briefly also respond to this notion that has come up that law enforcement also would like to retain access to sealed records for use in the field. Under this current iteration of the bill, they would not have access to sealed records for use in the field. We would like that provision to remain. We think it's important that when an officer is responding to a call, a roadside stop, that the information that is being considered is, again, not something that is antiquated and informed by old convictions from years in the past, but rather being able to meet that person where they're at, to consider the situation on the ground in the moment, and not be taking into consideration something that happened long ago that the offender has already met all of their obligations for.
Appreciate that. That, you know, that is a key point in my mind. So I appreciate that. What kind of information do they need? In small towns, like even some of the larger towns, families are well known to law enforcement. People are well known to law enforcement. It's not a secret. You know, obviously, if somebody's from out of state, they wouldn't know. They might have records, but you know, generally, the population is well known to law enforcement. And so, I'm wondering what it is that they don't have now that they would be able to gain through these sealed records.
I think that's a valid question, but I also would ask that whatever it is they would be able to gain, how relevant is it? How informative is it versus maybe actually how misinforming it might be. If you're taking into consideration something that somebody did 17 years ago, I'm not sure how relevant that is to considering your law enforcement response in the moment. A last thing I would just like to say, I'm seeing in my notes, Evan mentioned that 41 out of 54 states currently have sealing laws, even if they call them expungement laws, but it's not necessarily an apples to apples comparison. Many states only allow for the sealing of very few crimes. And so one thing that was very carefully considered in this particular sealing bill was the fact that an individual would not be able to seal violent crimes or sex offenses against children. And there are many crimes that are eligible for expungement right now that are also considered to be minor crimes. So to just say that most states have sealing over expungement does not necessarily mean that all states are allowing the very same crimes to be cleared from records.
Any other questions for? I believe the Attorney General's scheduled to speak tomorrow or next week. We look forward to hearing from him too.
Super.
Senator Sears.
Yep.
Aaron, this is Joe Benning.
Hi, Senator Benning.
I have not heard anybody talk about this yet, but the language on page 22, subsection 5, that presumes that the Attorney General and the state's attorney's office would have access to these records at all times. And I'm looking at the word may on line 4, and it gives them the discretion whether to release what could be exculpatory information or not. Do you see any ethical issues with that word being there?
Well, I think what's funny about this provision is that, well, you suggested one funny problem is that the Attorney General's office and the state's attorneys would maintain access to sealed records forever, potentially. There's no time limitation on this, unlike for sentencing purposes or DOC purposes. But the other thing is, yes, under in terms of ethical obligations to disclose exculpatory information, that is a must if you have knowledge. So if you don't have knowledge, in other words, if you do not have access to these sealed records, if you do not have an expunged record, then you would not have an ethical obligation to disclose. And so I think you've identified a kind of a funny language issue with this particular provision, where if it's supposed to be about ethical obligations, then why does it say may? And
so
again,
really
I would defer to
strike the paragraph is one solution, which is the one I'd prefer. Or you have to change the word may to must, because they shouldn't be given the discretion of whether to release information that they have in their possession.
And again, our office did not request this provision. And I would be very interested to hear from the Defender General's office, whose job it is to provide representation to defendants about whether they think there needs to be this, this provision for discovery obligations. I've not heard of any problems under the current expungement law. So again, that probably goes to why our office did not request this provision.
Probably. Are there other questions? Thank you so much. Appreciate it.
You're very welcome. Thank you.
Marshall Paul is our next scheduled witness. And I realize we probably won't get through all of your testimony today, but hopefully we can pick up with it tomorrow morning.
That's all right. I'll be as fast as I can. First of all, is everybody able to hear me all right? I'm on a new microphone setup.
Sounds like your new mic's working fine.
Excellent. So I'll jump right in, with this question of discovery obligations, since that's sort of, picking up the conversation where it's been left off. We do not oppose the paragraph 5 on page 22. I think it's 22. Yes, 22. But I want to explain the way that we understand that and why we don't oppose it, because we do profoundly disagree with the state's attorney's office regarding their discovery obligations and the impact of this legislation on those discovery obligations. This is something that's been addressed. I mean, we've had, just to give an example, we've had expungement in the case of deferred sentences in Vermont since the early 1970s, at least. That's as far back as I was able to track it. And this is not a problem that's come up in that context. And honestly, if this was a real problem, it would have come up in that context, because that is, excuse me, for the past 50 years, a scenario where records have been being not just sealed, but physically destroyed by the judiciary, and prosecutors have had full knowledge then of, convictions and records of convictions for witnesses and defendants that would have had to have been disclosed pursuant to their obligations under constitutional cases like Brady, and also statutory and rule provisions like the discovery rules. Also, this is an issue that's been addressed in many other states, and the problems that have been raised by the state's attorneys and sheriffs just simply aren't really problems. So, for example, the concern about Giglio letters, that's just not a concern. There's nothing in this bill that tells anyone what they have to do or not do with a Giglio letter. Giglio letters are not based on convictions. A police officer does not have to be convicted of some sort of an offense in order to be subject to a Giglio letter, that meaning that the prosecution has to disclose information that they know bears on the credibility of that police officer. So really, it doesn't make any sense that a Giglio letter would somehow be affected by the expungement law when they really just address two different subjects. An officer could have a conviction, that conviction could be expunged. That would not have anything to do with the Giglio letter. Nothing in here, nothing in this bill would encompass Giglio letters. And I think the same is true of some of the other concerns that have come up. For example, the concern about what happens if a prosecutor knows about someone's conduct that would reflect on their credibility, but a conviction relating to that conduct was overturned, or was expunged or sealed. And that's actually something that's been the subject of a whole lot of cases in other states where this has been more widely developed. And they've said the same thing in every single state, which is, once somebody has had their conviction expunged, then you can no longer use that conviction for impeachment purposes, and therefore that conviction is no longer required to be disclosed by the prosecution. However, if the prosecution knows about the underlying conduct, and if that underlying conduct reflects on that person's credibility, then the prosecution has an obligation to disclose what they know of that person's underlying conduct without mentioning the conviction, because you can still impeach with the conduct, even though you are no longer referring to the conviction, because legally the conviction no longer exists. So I would just say that to point out that when it comes to the ethical and constitutional and statutory obligations for disclosing certain information by the prosecution to the defense, we're really not concerned by this, because frankly, this has been handled by other states. This has been something that the state of Vermont has been handling since at least the 1970s, when we've had regular expungements in deferred sentence cases. And it's not something that's been a problem in Vermont in that time, and it's not something that's posed a huge obstacle to expungement laws in other states during that time. So while I completely understand why it's coming up, and I understand the arguments that are being made. It's our perspective that they really are not actually legitimate concerns, and that frankly, where there are legitimate concerns, they've been amply addressed in case law from other states that really spells out how you approach these situations. I'll take a step back and just sort of address the bill broadly at this point. Well, I want to make clear that our office supports this bill, and we support it for a few reasons. First is that this bill does expand the list of crimes that are eligible for expungement and sealing, and to us that's very important. Vermont has currently a very limited list of offenses that are eligible for expungement and sealing, and under this bill would be eligible for sealing only. Other states have much broader lists that encompass a lot more offenses. And from our perspective, our state's list is still cripplingly small. There are still Vermonters who have offenses on their records that should not be hampering their ability to get jobs, hampering their ability to find housing. And it really is even for very, very minor stuff. And I just want to give an example. I have a client, right now, who has a conviction on her record from 1992. It is 30 years old at this point. That 1992 conviction is for retail theft for a total of $200. And that was for this was someone who was working at a grocery store and was putting groceries in people's bags, in a friend of hers bags, without scanning the groceries or entering them into the cash register. So, a juvenile, a very childish offense back in 1972. To this day, she cannot get that record expunged, and that's prevented her, not just impacted, it has completely prevented her from being able to get a job and to get paid to be a care provider for a relative of hers. Her family has to pay for a care provider where she would otherwise be able to be hired by the company to be the care provider for her relative. She can't get that simple retail theft expunged because back in 1992, retail theft of over $100 was a felony. It no longer is. It's a misdemeanor. That offense today would almost certainly be sent to diversion. I can't think of any county where they would be prosecuting somebody for a first offense $200 retail theft in Vermont right now. And yet this woman cannot get her record expunged. And because she cannot get her record expunged, she can't get the employment that she wants and needs. And instead she's held back. In fact, the funny thing is that since that time, she continued to work in grocery stores pretty much her entire career because there wasn't a barrier to her working in grocery stores, but it has been a barrier to her, for example, working for this home health service. So from our perspective, I just want to bring it back to that. The expansion of crimes is a very important piece of this bill. We understand the concerns about who has access to those records. From our perspective, we supported this bill being a one-track system, not because we support a sealing system. In a perfect world, we would prefer expungement. The reason why we did not oppose a shift to a sealing-only system is because, frankly, under the current system of expungement, cases are not getting expunged anyway. Even though expungements are being filed and expungement orders are being issued, there's simply a backlog that has prevented expungements from actually taking place. And that had been the case for many years. We've been in here year after year talking about how difficult it is to get these expungements to actually take place. And so from our perspective, it was more valuable to move to a one-track system where the law reflects what's actually happening than to maintain this two-track system that creates this fiction that cases are being expunged when they actually aren't. And we also felt comfortable initially moving to the idea of a one-track system because from our perspective, the idea was to move to a system where we would have sealing rather than sealing and expungement, but that access to those sealed files would be limited in a way that's very similar to the way that access is limited to expunged files. I think what this committee can see and what we saw in the House was that as soon as we open that door, there's then been the request to include a lot of exceptions to the access to records provision. I think we've heard that from the state's attorneys. I think we'll hear that tomorrow from the Department of Public Safety, and we've heard it from Department of Corrections and various others throughout this process. And to our mind, our support for this one-track system is contingent on this one-track system having very limited access, similar to that of the current system of expungement. We don't want to be taking a step backwards where many, many more people have access in many, many more situations to records that under the current law would be very, very limited. And I think, since it's been talked about, this idea of the use of this information on the roadside, I completely understand Commissioner Sherling's position on that and the Department for Public Safety's position on their desire to have access to this information when making roadside stops. One of our concerns from the very beginning of the expungement laws has been to look at police use of records and when that's appropriate and when it's not. And I think recently that was highlighted in Dr. Seguino's report analyzing traffic stop data in Vermont and showing that, even after many years of talking about these issues in the legislature, of, making changes to how police are trained at the academy, to making changes to how, we're keeping data, that we are still nonetheless have extraordinarily high disparities in how police are interacting with Vermonters of different races. And I think one of those is particularly relevant to this conversation, which is how often police are requesting permission to search a vehicle. That information, we as defense attorneys see those requests. We see them on the body cams when an officer approaches a car that they pulled over for a very legitimate reason. But instead of simply writing a ticket and wrapping up the encounter, says, hey, I see you have a conviction for drug possession, for heroin possession on your record. Is that still something you're involved in? Or is that still something we need to worry about? Is something I've heard another way they phrased that. And that conversation often then progresses into a request to search, and then often then into a search. We see the tremendous disparity in how those requests are made and to whom those requests are made. And to our mind, limiting the access to really, really old and minor criminal convictions by police on the side of the road is actually a really important part of solving that problem. It's part of addressing that disparity. It's making sure that when an officer pulls over someone who has a, 7 or 10-year-old drug conviction on their record, that the officer who's pulling them over for speeding simply addresses the speeding and moves on and doesn't use it as an opportunity to start fishing about a drug conviction that's so old that we know that it doesn't have any predictive value, that person is not more likely to possess drugs than someone who doesn't have that conviction on their record because that conviction's so old. And I think that's sort of my final point. I know we're hitting the 12 o'clock hour. And so, the final point that I'll make is that I do think that this committee should hear, I know that David Diamora from Center for State Government has testified a lot, but I think it's very important to hear his testimony with regard to this bill, because the testimony that he's provided bears exactly on the points that we're talking about. It bears on what relevance does this information have and who does it have relevance to? Is it actually valuable to an officer on the side of the road? Is it actually valuable to a sentencing judge sentencing a defendant? Is it actually valuable to a caseworker at DOC making a casework decision? And if so, how long is it valuable and when does it lose that value? And I think the important thing to keep in mind is that we don't need to, this doesn't need to rely on a lot of back and forth from the witnesses. It doesn't need to be, me saying that this information is stale and not valuable, and the police saying, this information is, vibrant and valuable. There's been a lot of research on this. There's been study after study after study on these questions exactly. And I think that David Diamora is really the best one to come in and present that research and explain to the committee exactly what this information is good for and exactly what it's not good for. And I think that that would better inform this committee's decisions on when and how that information should be used.
A great
I talked
idea.
it over, but I'm happy to take any questions. I'll be as quick as I can.
I think we're going to hold the questions for tomorrow. And Peggy, if we could readjust the agenda slightly so that Marshall comes up first tomorrow morning, and if there are questions, if you're available.
I won't be able to be first. I teach a class at the law school first thing in the morning, but after 9:45, I am.
Okay. Well, put him on then. Okay, thank you very much, everyone. We'll pick up here. Peggy, do we have David Diamora on the witness list?
No, but I can reach out to him. When do you want to have him come in?
Next week sometime,
Not this week.
whenever he's
next week.
available.
Okay,
Huh?
next week, not tomorrow.
No, not tomorrow.
Okay.
Thank you.
Thank you.
See you all tomorrow morning.
Thank you.